All right, good afternoon, everyone. Happy Tuesday. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative. Thank you for joining us here today to learn about assisting immigrant children impacted by human trafficking. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You will receive a copy of this recording in an email from Zoom within 24 hours. The recording will also be posted on YouTube, where you're going to be able to find a link to the materials that will be used today. If you don't see that email, I'm just going to go ahead and drop my email anyway into the chat, just in case. Feel free to reach out to me for anything that you may need. This training is approved by the Florida Bar for 1.5 CLE credits and 1.5 certification credits for both juvenile law and immigration and nationality law. I will announce the CLE code at the end of the session. I will also drop it here on the chat, and it will also be included on the Zoom email that will go out. Closed captions are enabled for anybody who needs them. If you are having any issues with accessibility or the captions, you can reach out to me directly. And final piece of housekeeping announcements are questions and answers. If you have any questions, you can drop them on the chat or in the Q&A towards the end of the presentation. If time permits, we'll answer as many questions as we can. I'll go ahead and read the question out loud. If one of the presenters sees the question and they want to answer it live, they can do that as well. And be on the lookout for whenever I put down the information for the CLE code, I'm also going to drop a link for a survey. We would really appreciate it if you take some time to fill that survey out. So without further ado, I'd like to introduce our speakers today. First, we have Jacquelyn Bradford. Jacquelyn went to Florida State University for undergraduate studies and then served in the U.S. Peace Corps in Mali. She holds a Master of Public Policy from the University of Michigan and a JD from the New York University School of Law. Jacquelyn has been representing foreign national adult and child victims of crime since 2013. In her current role, she primarily assists survivors of human trafficking with immigration cases. She also trains and mentors team members, conducts external trainings and outreach activities, and provides free technical assistance on human trafficking related issues. Our next speaker is Nicole Avila. Nicole is a graduate of Nova Southeastern University in Davie. She worked in private practice for 6 years, focusing on assisting survivors of trauma. She has represented victims and survivors of domestic violence, human trafficking, and other crimes in immigration matters, assisting them with seeking relief under VAWA, U, and T visas. Nicole has also represented families seeking adjustment of status before USCIS and clients in removal proceedings seeking asylum, cancellation of removal, and other relief. Nicole has been the co-chair of the Immigration Law section of the Broward County Bar Association for 3 years, a director of the board of the Broward County Hispanic Bar Association, and a member of the Stripes Committee of the Broward Human Trafficking Coalition. She has frequently presented at CLEs and conferences speaking on various immigration topics, including visas and other relief for victims and survivors of human trafficking, current issues on immigration law and policy, and immigration consequences of criminal conduct. So with all that said, thank you again to both of our amazing speakers. So I'm going to pass it off to Jacquelyn. The floor is yours.
Hi, everyone. We're glad you're with us today. Start off by just giving a little information about our programs. I'm with Gulfcoast Legal Services. We're a civil legal aid. We primarily serve clients in the greater Tampa Bay area and in Manatee, Sarasota area. And we have a Department of Justice Office of Victims of Crime grant for serving victims of human trafficking. We can serve survivors of labor and sex trafficking, adults and minors. And as Jorge mentioned, we also offer trainings and technical assistance. So if you ever have questions about referrals, a case-specific issue, or just a general topic relating to human trafficking, if we have the expertise to answer it, we will do our best. And if not, we will also try and give you some referrals to resources where you might be able to get that information.
And a little bit about our program here at Florida Legal Services. I am the Immigration and Bono supervisor for our VOCA funded project, as well as the anti-trafficking legal services supervising attorney. And we have both VOCA funding and funding, federal funding under the Office of Victims of Crime, where we can serve survivors of human trafficking in 9 counties in Central Florida. And through our VOCA funding, we can serve the other remaining counties where there might not be already services or legal services for survivors of human trafficking and other crimes. We also do provide some technical assistance or help workshopping issues. Or so I echo Jackie. If anybody has any questions or needs some guidance, we're happy to talk with you and workshop those issues. So today, our learning objectives for today are to that folks should leave this webinar able to identify immigration needs of children that were born outside of the United States, recognize the benefits available to children who were born outside of the United States who have experienced trafficking victimization, and also being able to define exploitation and trafficking victimization of children. We do want to touch on some foundational issues that we're not going to delve deeply into during this presentation that we might mention. So we recommend that folks have some basic knowledge of these things, including immigration law concepts, like a number, entry, parole, who the agencies are. We're going to talk a little bit about statutory definitions related to trafficking victimization, but we're not going to talk about it very deeply today. Trauma-informed and culturally sensitive service delivery. And for today, or when we use the term children born outside of the United States, what we mean is a child that has any type of status other than US citizenship. And just a quick refresher on trauma-informed practice. We want to make sure that our service delivery, our representation is trauma-informed, so that we're showing the child that we are a safe person, and that we're trying to help. And so we want to make sure that we're using the language that is the child's best language, which a lot of times I've experienced with especially Central American children who come from remote villages, that their first language might be an indigenous language. But there's a lot of stigma associated with that in their home country. So they might tell you that Spanish is their best language and that's the language they would like to speak. And so trying to go with the child's preference, and many times they'll just say things like, oh my gosh, you speak another language, that's great, I only speak Spanish and English, tell me more about your language, things like that, so that we're building rapport and there isn't the same stigma. We can get an interpreter that might be able to assist in their native language, so that we're addressing things in a way that the child best understands. We also want to make sure that the relationship is collaborative and that we try to balance out any power imbalances that are inherent in not only an attorney-client relationship, but in working with children. So be transparent about what your role is, what you can and cannot do. Talk to the child about what their goals are, if it is remaining in the United States, if it is not remaining in the United States, so that you can discuss the risks and the pros and cons, essentially, of either of those outcomes and what is actually possible. Remember that they're in a system through both the child welfare system and the immigration law system that are confusing for even adults. So we want to make sure that we're explaining things in the language that they understand and in terms that they understand. I always tell my staff, or when I do CLEs for attorneys, that lawyers speak their own language. We are trained in law school to use all of these words that most other people that don't practice law don't understand. And so we really have to make a conscious effort to stay away from that and speak in lay terms that are understandable by everybody, so that we are in the same that we're speaking the same language when we're speaking with a child or any client. And that we're allowing them to make the choices that they can make. Their children, most of the things that they're experiencing are outside of their control, but as much of that power as we can give back, especially when we're talking about survivors of trafficking victimization. So because they are still, people with agency who have experienced some very traumatic things, but that is not their whole story. It is part of their story in treating folks like whole people who have priorities related to their legal issues and priorities that don't relate to their legal issues, and helping to guide them through the process. And always keeping in mind any cultural, historical, or gender issues that are prevalent in home country and in the US with regards to systemic issues, and why folks might not want to engage with law enforcement, for instance, or why they might be wary of speaking with the folks they're interacting with within the child welfare system. So I'll pass it over to Jackie, I think, to start with our sources of law. And let me see. Or is that still me? Sorry. Sorry,
okay.
Jackie, I don't have
It's
the list.
it's okay. Yes, it is still you.
Okay,
I was just gonna I'll
perfect.
chime in really quickly
Yeah.
with a couple things that I want to make sure everyone's aware of. As Nicole mentioned, we're using the word children born outside of the United States to mean children who are not currently US citizens. Want to be clear that some children who are born outside of the United States are US citizens, but to have evidence of that citizenship, it can be a lengthy, epic process. So while we don't want to say anything to seem like they are not real US citizens. They are US citizens. However, they will be treated like they are not US citizens until they have that evidence. So they still need to go to an immigration attorney. So that's why really just all children who are born outside of the United States will need to go to an immigration attorney. And sometimes we might say immigrant children. I might slip up and say foreign national children because that's what I frequently use. But what we really mean is kids who need to see an immigration attorney in general. And I think, and then yes, as Nicole also said, we want to make sure kids know who we are, especially children in the child welfare system. There are so many adults that they're interacting with, and sometimes they change. So even if you haven't changed, even if you've been on the case for a couple of years, they still might not know who you are or what your role is. It's so overwhelming. I think for everyone, including when new attorneys start to work on these kind of cases, it can be overwhelming, right? So just want to remember that for children to build trust and to understand what is happening. And they need to be able to understand what's happening to make choices, right? They can't make choices if they don't know what the choices are. So we just want to make sure we really take the time every time we interact with a child to go over these things. And if they, know the answers, if they're on it, yeah, move along, but make sure they know who they're talking to, because if you're their attorney, that's a huge difference, right? Like they can speak to you about things that they want to keep confidential versus if you're a case manager, there needs to be that transparency so you can build rapport so that they'll still choose to tell you things, right? So we just want to make sure we're doing that every time we interact with kids.
Absolutely. Thank you so much, Jackie. So one of the things that we wanted to highlight for this is that the Florida statute under Chapter 39 mandates that the department or the community-based care provider determine whether the child has status if they're a citizen of the United States, and if they do not, that they report to the court not only about the status but what steps they have taken towards getting that child status. So and so because this is under Chapter 39, this is applicable to children who have been abused, abandoned, or neglected and might be dependent under state law. And so services that would be applicable or that would be provided to children who are citizens of the United States and their parents should be provided regardless of citizenship status. But the court does need to be aware that the child is not a citizen and what steps the department is taken through any service providers that they work with. And so we want to make sure that kids, you're going to hear us say this 100 times throughout this presentation. We want to make sure that kids are connected with an immigration attorney. As soon as the person working with the child realizes that this child may not have status, they should be connected with an immigration attorney that has experience in working with children without status, because there are deadlines that might come up, and there are a lot of nuances within the immigration law that might affect what type of status the child might be able to get. And so we want to make sure that any documents, identity documents, documents that show any citizenship or nationality, such as a passport or a birth certificate, if those documents are available, that one way that the workers or the case managers or caseworkers, guardians that are working with the kids can gather those documents and share them with the immigration attorney. You can get requests for release so that you can request a release from the client so that you can share that information with the attorney. It goes a long way into identifying what those needs might be and what the child might be eligible for. But I know that you're going to be tired of us saying they need to connect with an immigration attorney, but I do think that is the largest takeaway from this presentation. I've heard people say things that immigration attorney or immigration law is about as complex as the tax code. So we don't want to put that burden on you to have to learn everything about immigration law. We do have, experts all over the state in the counties that Jackie serves. You can connect with her program. We serve statewide, so if the children are victims of any crime, they can contact our program, and we'll be able to provide advice and at least guidance in that regard. Is there anything you want to add to on that, Jackie?
I'll just do one quick, again, for all children who were born outside the United States. Generally, throughout the presentation, we're going to try to speak about things at a really high level. And, like the lawyer's favorite, right? It depends. There are for sure exceptions in various issues, and we're not going to have time to get into all the exceptions. And also, you probably don't need to know all of them. But I did want to give an example to illustrate why all children who are born outside the United States need to see an immigration attorney. So usually during the presentation, we're going to think about children who don't yet have a green card. They don't yet have legal permanent resident status. But I want to specify that even children who already have their green card, they also need to consult with an immigration attorney. And I think that's not always happening, especially if the kid has their documents and they have the Social Security number. Case management's able to enroll them in Medicaid without issue, right? I think folks aren't necessarily thinking, oh, we have an immigration issue. But everyone who is not a U.S. citizen has obligations and responsibilities until they become a citizen. And we need to make sure that kids know what those are if they're old enough. We need to make sure caregivers or someone who might adopt the child, they need to know that too, right? So we need to make sure we're consulting with an immigration attorney, one, just because even if there's nothing wrong, folks could make a mistake that causes a problem, or they might not be aware of the next steps in that child's immigration journey. And then two, sometimes there is something wrong that we don't know about. And so if the basis for the child having their green card was not proper, right? Maybe there was a mistake. If we figure out there's a mistake while the child is still a child in care, there's almost always something we can do. But if we don't think there's any issues, and then let's say when they're 22, this now young adult applies to become a US citizen, they could be at risk of losing their status and not having other options available. So that's why I just want to emphasize again, any child born outside of the United States, please make sure they have a consultation with an immigration attorney, and that any potential permanent caregiver for that child is also going to have the knowledge they need to be able to successfully take care of all of that child's needs, which for a child who's not yet a US citizen is going to include immigration needs.
Awesome. Thank you, Jackie. That's a really great point. So what we'll need, like Jackie said, is going to depend on the case. Even cases that are very similar, even siblings sometimes whose stories match almost exactly, are going to have different cases. So we might need information from the parents or caregivers, and that the immigration attorney can then use to figure out whether there is status in the past. Like Jackie mentioned, there are some children that might have been born outside of the United States that might be US citizens, and whether those processes were followed so that they have proof of that citizenship, or if there isn't any documentation that might show, like I said, where they were born, evidence of nationality. There's folks who have multiple nationalities that might present issues in certain types of relief, like asylum. And there are folks who are stateless. So any paperwork, any documentation that's government issued, IDs, things like that, that might go to show the status of the case, or where the child stands at the start of the case. And any information that the attorney might request. If the child has already interacted with immigration at some point, the attorney could request, under the Freedom of Information Act, the child's file, to review anything that might have been filed for them in the past. But that can take upwards of 6 months in many cases. So anything that you already have access to, or the child might have access to, is important to share. And the process with immigration, unfortunately, there is an enormous backlog for every type of relief. And so we're looking at a process that could take several years. However, for children that are in care and are dependent under Chapter 39, they have options while the case is pending, and they'll still have access to a lot of the benefits and the potential either public benefits or things that the state offers. So we're going to touch on that a little bit later as well. And then it's important that we move quickly, because some forms of relief are only going to be available if we seek the appropriate orders and the appropriate processes before the child turns 18. So especially when we're talking about older kids, sometimes we have to move very, very quickly. And especially if they've already had interactions with immigration, they might be in removal proceedings. And so that might mean that they'll get a removal order or a deportation order. And so we have to move very quickly to prevent that from happening, and ensure that if they're eligible for any status, that can happen quickly. Jackie, anything to add to this one? All right, awesome. So the first question is, where was the child born? Were they born outside of the United States? And that's where you're going to say, okay, they were not born in the United States, so we're going to send them to an immigration attorney right away, and have a consultation with the child to figure out what those legal needs are. And especially if the child is going to be adopted, that's important, and that the potential adoptive parents and the child have that consultation so that everybody is on the same page regarding what the status might be. I've seen cases of children that were brought to the United States as very young children, and no processes were ever started for them. And so now as adults, they've been here with presumptively adoptive parents for a number of years. They've now aged out and have no status, and there's really not anything that can be done at that point because they have aged out. we mentioned before, if the child is 16 or older, it is especially urgent because processes take such a long time, and the dependency court will not be able to take jurisdiction generally if the child is over 18 in Florida. And if the child has any documentation, the attorney will like to see it. It's very important if the child has multiple citizenships or passports, or if there's any question about where the child was born. I've seen this commonly with folks that were born in the Bahamas or Haiti, where there's some sort of dual citizenship with the parents and things like that, so that we can determine where they're from, because that'll affect what, in certain cases, whether they're eligible for additional things like temporary protected status for Haitian nationals and things like that. The other big question that we want to know the answer to is whether the child has been issued a notice to appear. The notice to appear would be issued by one of the immigration agencies if they entered through the border without inspection. Most commonly, they would be getting it from Customs and Border Protection. But it could also be issued by the U.S. Citizenship and Immigration Services or Immigration and Customs Enforcement, which is the enforcement arm or the police for immigration. So any of those agencies could potentially issue a notice to appear, and this is what that looks like in general. So if you see this in the child's packet of documents that they got when they were, if they were in a shelter at any point with immigration or anything like that, you want to make sure that you see, look out for this, because that'll affect what relief they might be eligible for, where it has to be submitted, and whether the attorney has to take additional steps to protect the child's status and stay in the United States while the dependency process develops and completes. We also want to know, this also kind of goes along with whether they spent time in a shelter with the Office of Refugee Resettlement. Like I mentioned, that was, if they were in a shelter, they're most likely in removal proceedings or deportation proceedings. And many times we've seen where the child might also be dependent after they're released from shelter. But there's times where the court might not want to take jurisdiction because they think that ORR has jurisdiction, but we still have the duty and the law in Florida still, if the child is dependent or has been abused, abandoned, or neglected, and should be placed in dependency, you're still able to do that, even if the child was previously in ORR care. They do not need to go back into ORR care, and that might actually be more detrimental to the child. The child might also have a packet with them. So ask them for any paperwork they would have received at shelter or that they received from immigration or at any time. Usually they give them an envelope that has a form like this one that you see on the right-hand side of the screen, that'll have their picture on it. That can serve as a form of identification and gives us a lot of really good information. Jackie, do you want to add anything?
Yeah, I'll just add they can't go back to ORR is my understanding. There may have been, again, everything has an exception. But yes, even if sometimes folks are confused and they're trying to do what's best for the kids and they call, and ORR will tell you they go into the child welfare system if there's a placement disruption. And we're not going to get into it, but since I'm already talking, I'll just say, there's lots of reasons why that happens. Some of the kids, haven't seen the caregiver in potentially decades since they were a baby. So that can be fraught. Also, sometimes it's someone they've never met before, maybe a distant family friend or a sibling that left before they were born. So there's lots of reasons why we see placement disruptions, and sometimes those children do experience, abuse, abandonment, or neglect, and they need to go, or there's a caregiver unavailable, so they need to go into the child welfare system. And I just want to do a quick shout out to everyone who's putting comments in the chat, and we'll also answer questions through the Q&A as well. So thank you for participating. Folks are stating that someone had some experience working with children who were adopted improperly. by U.S. parents. And unfortunately, those can be the most heartbreaking cases, because if it's discovered when they're children, especially children who are now in the child welfare system, almost certainly there's going to be a form of relief available. But sometimes it's not discovered until these folks are adults and there's not always anything available for them, or maybe they're applying for their Social Security and they're planning on retiring and they're learning for the first time that they're not lawfully U.S. citizens, is there not much to be done. And right, they don't, all of their retirement is here. So anyway, that's not really on topic, but just want to mention, yes, these issues are so complex, and even immigration attorneys, especially like in the realm of adoption, if they don't do it regularly, they might give folks bad advice and lead to these scary outcomes. So just, yes, it's always very important, and it can be very challenging to fix issues, but thankfully for children, especially in care, there's almost always going to be something we can do as long as we get them to an immigration attorney with expertise in these issues.
Absolutely. So as folks that are working with children that might be in deportation proceedings or removal proceedings, there is a way to check on that even if you don't have that notice to appear document. I'll go back just briefly. The ORR release form that has their information and their photo usually will also have their alien number, their alien identification number. It's a number that's going to start with the letter A, and it's usually about 9 digits. And so you would plug that in, and the QR code is here, so you can kind of bookmark that website. But you can plug that number in on the EOIR, which is the Executive Office for Immigration Review. That is the immigration court. And it will tell you whether the case has been filed, whether there's a case pending or not pending, and if it's pending, in which court and before which judge, and whether they have a hearing scheduled, or if they missed the hearing, it would show that there is a removal order entered. So that information is very important for the immigration attorney to have. So if you do come across that information, make sure you can do a printout of that website, or just make sure you let the immigration attorney know that there is a concern that the child is either in immigration proceedings or that they already have a removal order. Sometimes the abuse can include not giving access to mail that's coming in, or not taking the child to court and things like that. And maybe it's not even the abuse, but just fear of the parents of having to be in the immigration system. So, but it is very important, if they have a removal order, that's addressed as soon as possible. There are time limits and number limits on how many times folks can ask to reopen a removal case. So it's important that it's addressed as soon as possible. And as we mentioned earlier, the court, or the Florida law, does require that the Department of Children and Families, or the agencies that are working on behalf of the Department of Children and Families, report the status of the child to the court and the steps that they have taken to address citizenship or residency status of the child to the court. That includes whether the child is eligible for special immigrant juvenile status, which we'll explain more about in a little bit. Petition the court for the required order so that the child can apply for special immigrant juvenile status, and that the application to the U.S. Citizenship and Immigration Services is submitted within 60 days of that order. So connecting with the immigration attorney as soon as possible will enable the person that's working with the child to be able to make that report to the court, to screen the child for eligibility for immigration relief, and coordinating the parties, whether they need to engage with a dependency attorney for the child, or somebody that can help secure those orders, and provide all the information that the court needs. But the department does have the responsibility under statute to make sure that this happens, and to take the appropriate steps to connect the child with the service providers and legal service providers that can make this happen. So again, our biggest takeaway is connect the child with an immigration attorney as soon as possible. And as we mentioned earlier, we're more than happy to address questions and help connect you with the folks that might be able to make this happen for the kids you're working with. So I'll pass it over to Jackie.
And we have another question about whether or not these children customarily get a gal, as any other child might have appointed, or is this different? And the person's saying they would be interested in working on a case like this.
Awesome. Love that question. So if the child is in dependency proceedings, there's already been a petition filed, then they would get a gal, same as any other child that's already in court. But that's not necessarily the case if they're not already in that proceeding. And I know that many times, even though there's allegations of abuse, abandonment, or neglect, for one reason or another, the child is not in care and it comes before the court it might be in the family court, or it might be in like a guardianship court or something like that, under Florida statute 751 for a kinship guardian or a caregiver that's related to the child, and they're going to have custody. So it might not already be in the dependency court, and in those cases, the child might not get a GAL. But if they're in dependency under Chapter 39 in front of the dependency judge, then typically they would, as long as that's what's done in your circuit. Yeah.
Exactly. So children who are in care, who are foreign nationals or were born abroad, will usually get a gal. So if you're interested in working on a case with a child who was born abroad, I think you should say that to your gal program probably. I think they would be the ones who assign cases. So knowing you have an interest and that you're willing to, learn more about these issues, or if you already have some expertise, I think that would be great. I think a lot of times they try to prioritize folks to match with language capabilities. But of course, that's not always possible because we don't have enough folks who speak Spanish, let alone some of the other languages that are a little less common, or even much less common, like some of the indigenous languages, like Nicole mentioned, or folks from, countries that aren't as close to us as well. Even though millions of people might speak the language, we might not have many folks living in our county who speak that language. So in that case, folks will have to rely on interpreters, and really anyone who has interest and is willing to develop some expertise or has it would be a great fit to be a gal for those kids. Okay, so now we're going to shift from talking about, what we're going to do to get the kids to an immigration attorney, and a little bit to give you some overview about, what might be an option once we get that kid to an immigration attorney. So we're going to be at this stage after we do the stuff that Nicole talked about. We've connected the kid with an immigration attorney, and the immigration attorney it might be, can be an iterative process, but at least done a review of all of the initial documents that have been gathered, things related to the dependency case itself, right? What are the allegations? What documents are available? Things related to immigration status and history, identity documents, etc. So then when the child is connected with an immigration attorney, they're going to screen the child for any forms of relief that the child might be eligible for. And they're going to screen the child, like I said, by reviewing all these documents and by interviewing the child. And that's a very important step. So some of the statuses that children might apply for include visas for survivors of human trafficking, called a T visa. And, we're going to talk more about human trafficking later on in the presentation. Special immigrant juvenile status, which is sometimes called SIJS or SIJ, or some people even say SIJs, I'm not sure. And then I say SIJ. Other immigration relief, which could be a U visa, VAWA self-petition, asylum. Maybe they're citizens, so getting that documentation. Maybe they're eligible to apply for their green card right away. So anyway, figuring out what status they're eligible for. We're going to talk a little bit more about T visas and SIJ today, because those are probably the most common statuses that children who are in care and survivors of human trafficking will apply for. And before we talk about an immigration status, we're going to talk about something that is not actually an immigration status, but allows a child who was born outside the United States to access public benefits. And this is called an eligibility letter. So the U.S. Department of Health and Human Services can issue eligibility letters. The letter is issued for children who have been identified as a victim of human trafficking under the federal statutory definition, which we'll talk about more later on, a victim of a severe form of trafficking in persons. And it includes a trafficking victimization that occurred any time in the child's life, anywhere. So in the US, outside of the US, you know, somewhere they only were for a day, anywhere. And it can be attempted or completed. And that goes for whenever we say a victim of human trafficking. Generally, it's going to include folks where there were attempted trafficking, and not going to get into those details, but, acts where someone attempted to do something or was, planning to do something, and those acts kind of reveal that plan. Or where it was completed, right? The child actually had to do some kind of labor or service or performed a commercial sex act. It's very important that the request for the letter has to be submitted before the kids are 18. It can be submitted the day before they turn 18. It has to be fully submitted though. So ideally, we don't want to wait till the day before they turn 18. And OTIP, the Office on Trafficking Persons, which is part of HHS, offers trainings on how to submit those requests. So if a case manager is interested and available, they could go through some trainings. If the child has an immigration attorney, sometimes it can be best for the immigration attorney to do that piece of it, but we all know that there can be delays in getting children connected with providers, including immigration attorneys. So sometimes, especially if that case manager or other party has expertise or has watched the training, so they have enough training to be able to do it, they can do it themselves. And they are routinely done by case managers in the OR setting or by other service providers. So it's not like a legal case or anything like that. And then upon issuance, the child will be eligible for public benefits to the same extent as a refugee. And that's more or less to say fully eligible for public benefits. Not going to get into the details. There's some time limitations that, for example, for SSI, but generally speaking, they're going to be fully eligible for public benefits like a US citizen, like refugee. It's usually processed very quickly and the letter never expires. So this is really wonderful because one, immigration processes usually take a while. So this can be something that allows the child to access, if they're in care, usually Medicaid's what they're, needing pretty quickly. If they're out of care or if they're going to be reunified with someone, right, who's low income, it could be huge because that's food assistance, right, all sorts of benefits, potentially housing. Anyway, very important, and it never expires. So even if the child later on, they don't have needs for a long time, 10 years later, they become disabled, right? They can still use that letter. I forgot I don't have it on my computer, so I'm like trying to tap it. Okay, sometimes children will have one of these letters before they enter child welfare system. And it might have been issued while they were in the OR shelter. So the letter in that case usually is not going to indicate that trafficking happened in the United States. Often will indicate that the child experienced a trafficking victimization either in their home country or maybe on the journey, maybe in the US before they are apprehended by immigration. So they might already have this letter. Or sometimes children will get it after they're released from OR shelter, or they've never been in OR at all, right? Children who've never been in an OR shelter, they're usually going to have gotten it with the help of someone. So a case manager, someone like me, an immigration attorney. So what this means is if a child already has one of these letters, there's probably going to be someone that has important information about their history and circumstances that their new immigration attorney will need. And then also to reiterate again, the letter is not an immigration status. It does not offer protection from deportation. It does not allow the child to live in the United States, to have, you know, an identity document, to drive, to travel back and forth, right? So it's not something where, oh, we have this, we're okay. We still need an immigration attorney. Next slide, please. Okay. So this is going to be a very, very high level explanation of T visas. We're going to mention this later on, there are wonderful resources available to give you in-depth knowledge relating to different immigration benefits, including T visas, if that's something you're interested in. But today, just for, you know, to give folks an overview of what it is, that if they encounter a child with it or a child, they're wondering what's going to happen to their kid they're working with, giving some examples. So T visas are for victims of a severe form of trafficking in person, which is just the federal definition for human trafficking. It is very specific. We'll talk about it later. It's a little different from the Florida definition for human trafficking, but most of the state definitions are kind of based on the federal definition. They're not, you know, miles apart by any means. Generally, the trafficking must have occurred in the US. I say generally because there are always exceptions, and it's important to talk for an immigration attorney to do that analysis. Minors who have experienced trafficking victimization and are applying for a T visa are not required to report their victimization to law enforcement. So that's really huge because kids might be tons of reasons, and Nicole alluded to that earlier, why a child may be uncomfortable reporting to law enforcement, including that these cases are messy and frequently traffickers might be someone that they have some kind of relationship with, whether it be a family member, a neighbor, someone who's prominent in their community, right? So they might not want to have that criminal justice enforcement going on, even if they're not afraid of the police. But, you know, there's lots of different reasons. That's just one example. The application must include a personal statement. And so the child does have to be willing to have some level of discussion about the trafficking victimization and for that to be shared with USCIS. These applications are confidential, so definitely we want to make sure that any discussion about these requirements happen between the child and their immigration attorney so that we can be very clear and address any concerns the child has and help them decide among options if they have multiple options and what they want to do. And it can be based on their priorities and their goals. It allows for employment authorization upon approval, or we have a new bona fide determination process. We don't know yet how quickly that will go, but right now I think T visas, oh my goodness, I looked up the other day, maybe we're at 1.5 years. So probably the bona fide determination will mean that they would be able to get an employment authorization before 1.5 years. But it starts this fall, so more information should be coming soon. It might be a while before we get a feel for it. And also, you know, since it's new, it might take USCIS a while to pick up the pace. But hopefully less than 1.5 years. It allows, the T visa allows for an application for a green card, usually 3 years after approval. So that's generally what we want to plan for. And the kids must apply before the T visa expires. So that's why they have to have an ongoing relationship with an immigration attorney. And with the T visa, the kids can apply for qualifying family members. And again, we're not getting into all the specific eligibility requirements, but there are more eligibility requirements. But in general, if someone is under 21 when they submit their T visa application, they can apply for parents, unmarried siblings under 18, if they have any unmarried children under 21, which of course, everyone who is under 21 will have a child. If they have a child, the child is under 21 by definition. And if they have a spouse. So just want to note that that's an option for, that's some children who have experienced human trafficking will be eligible for. And next slide, please. Okay, and then special immigrant juvenile status. Sorry, I see a question. We're gonna probably hold that one to maybe the benefits section. Okay. So if a child has experienced abuse, abandonment, or neglect under Florida statute definitions, they may be eligible for special immigrant juvenile status. Today, we're talking about children in the child welfare system primarily. And so for those kids, they're of course not living with both their parents if they've been sheltered, right? If a child is currently living with both of their parents, then they generally will not be eligible for SIJS. So why would kids want SIJS? What's the benefit? It will allow the child to be eligible for consideration of deferred action and to have a work permit. The deferred action decision is case by case, but so it's not a 100% automatic grant of deferred action, but the vast majority of children will be eligible. And if the immigration attorney has a chance to look at their history, they'll be able to give them a pretty good idea of whether it will be granted. And then eventually the child will be able to apply for a green card. So it's a path to getting a green card. It does require a state court order with findings and the factual basis for each of these findings. And so for children who are in the child welfare system, or for children who have been in the child welfare system and have not been reunified with both their parents, it's usually pretty easy to get this kind of order. It's not something that the system will automatically produce. It is something where we'll have to add some findings in, but they are best interest findings that judges routinely make on a regular basis. So it is for sure within the, purview of the judge. And so the specific findings are the child is dependent or in court-ordered custody of an individual or an entity. So just to be clear, if you've worked with a child who was put in like a permanent guardianship, so their dependency case is closed, as long as they're still at a minimum under 18, possibly older, depending on what's going on up to 21, we need more information. They can still be eligible. And then 2, that the child cannot be reunified with one or both of their parents due to abuse, abandonment, neglect, or a similar basis under state law. And for that one, I just want to note that as long as we have that dependency adjudication for kids in care, it's generally okay if their case plan is still reunification with both parents. They cannot be reunified with both parents while the application is pending. And often if reunification with both parents seems imminent, it's probably not going to be a good option for these kids. However, sometimes the case plan goal might be reunification with both parents when the practicality of that goal being implemented is incredibly low, right? Like if one parent lives in the United States and one parent lives in another country and there's no intention for anyone to move, then the odds of that happening are very low. And so that would be a case where SIJ is probably still a really good option. And again, these are very specific issues that that the immigration attorney will be able to provide advice on and also, get more details of what's going on with this specific child's case. And 3, we need to be able to say that it is not in the child's best interest to return to the country of nationality or last habitual residence of them or their parents. And that's usually a very low bar. We just have to specify why, right? If the judge is saying that the child should stay in their current placement, they have made that finding if their current placement is not in their home country, right? Or if the goal is adoption by someone in the United States. So we just need to flesh out like, why is that in the best interest of the child, which there's usually many reasons based on that specific child. Next slide, please. Okay. And then to give a little more information about why even a child who has experienced a trafficking and victimization might still want to apply for SIJ. So children might not want to disclose about victimizations, any kind of victimizations, including a trafficking and victimization. They might not want to engage in the T visa process. It does require, like I said, a personal statement, conversations at a minimum, or writing things about things that have happened to them. So they might not want to be involved in that. And there are other reasons as well. We're not getting into all of the eligibility requirements, but there are definitely other reasons that could be related to the eligibility requirements, or to the child's goals, right? Every child, as Nicole said before, is a full person who's multifaceted, right? And they might have specific goals. that make one status a better option for them than another. And so attorneys are going to screen for all kinds of relief and then advise the child of what those options are. And I wanted to note here about identification interviews and when we say the immigration attorney is going to screen. So as we mentioned before, immigration attorneys are definitely going to look at the record that's available to see what facts have been alleged, but we're also going to have interviews with the child. And so a child, there may be no reason in the record to suspect a child has experienced a trafficking victimization when they really have. Just like there might be physical abuse or sexual abuse that's occurred that is not described in the record, right? It might look like a purely neglect case. And even after multiple screenings and, tools have been used and folks have built relationships and know these children really well, they still might not be aware of everything that this child has experienced in the past, right? Because children have lived many, many days, and we don't know about all of them. And we don't know what's currently happening to a child in their current placement or at school, et cetera, right? So just want to make sure we always remember that children may be able and willing to share information only in certain contexts with certain people or based on other factors like the passage of time or receiving, services or therapy, feeling secure and safe. And that a child could disclose a past victimization or a current victimization at any time. And determinations of whether someone's a victim of a crime or a victim of human trafficking are not fixed, right? They can change. And so I think sometimes it's tempting for all of us, and I think we just need to remember not to have assumptions, especially when we're talking to kids, to really listen, to really be open, and to ask questions as appropriate, because it can be, I think, sometimes tempting to think, oh, I know this kid. Especially if you built a really, strong relationship with them or spent a lot of time with them. But I think sometimes it's tempting for folks maybe just looking at the papers to feel like they, know what's happened to this child or know what this child is currently experiencing. And none of us can really know that, right? So just want to be mindful of that, and also mindful that I think, especially with human trafficking, folks tend to reach out for help, which is great, right? Like they might check in with someone like me or Nicole. They might check in with law enforcement, and they're fulfilling their mandatory reporting duties. So they're checking in, does this sound like trafficking? And just want to remind everyone that no one has a crystal ball to explain whether someone's experiencing trafficking, right? We are listening to what you say and making a determination based on what you've told us. So I cannot tell you that a child is not a victim of human trafficking, right? If you give me a little fact pattern, I can say, well, that fact pattern itself does not include a trafficking victimization. But that doesn't mean that child hasn't experienced trafficking. So I've heard folks say this after speaking to, for example, a law enforcement agent. And I've also heard folks say this to children, like, you're not a victim of human trafficking. Like, oh, please don't say that. Please don't tell a child that they are not a victim of anything, because you don't know, right? We need to speak in more nuanced ways. And we also want to make sure that we're, building positive relationships with children. So just want to throw that out there as a little reminder. Next slide, please. Okay, I'm not going to get into all of this. You will have access to these slides if you want to check it out later. But the main takeaway is to show that while SHIS is wonderful to have an immigration status, it does not come with all of the public benefits that we would like it to come with. So that's why it's very important for children. And side note, many immigration statuses do not come with public benefits. So if a child, and I think most for at least time periods don't. So if a child is eligible for an eligibility letter for any reason, from trafficking in the past, somewhere else, from trafficking here, we want to apply for that child. And of course, an attorney only wants to apply for it for the child with their permission, of course, and with their informed consent. But yes, the eligibility letter is very important. So we want to make sure we submit that before they turn 18. And then the TV says, let's get them the immigration status if they're eligible for that. They can also apply for SIJ and get an eligibility letter. So it's in no way, oh my gosh, irreconcilable. And I think we had a question earlier about FAFSA without a social security number. So they will get a social security, okay. Okay, so let me read the question, sorry. So the kids will receive FAFSA without social security number. And I've been triggered because getting kids benefits who have the eligibility letter can be such a pain, but they're eligible, which is huge because compared to not being eligible, right? But it can be a big pain. So for example, if a child has an eligibility letter, they cannot have a social to work. However, they can have a social for the purpose of public benefits. So they can get a social for that reason. The process is complicated. But I want to flag for FAFSA, right? That's somebody is usually already 18. I guess maybe they could be 17. They should have a social security number before they turn 18. Now it's possible that through no one's fault, a kid gets put in care 2 weeks before they turn 18. They're immediately referred to an immigration attorney. They will not have a work social before they turn 18. But most kids are not being put in care a few weeks before they turn 18, right? So that's why, especially like Nicole said, 16 and up, it's urgent. We want to get them to an immigration attorney right away. And then by the time they turn 18, they should be able to have a social security card. You know, again, processing times can change, but they should. And generally, and then if they have that social security card and they have the HHS letter, the HHS letter is going to be what makes them eligible for benefits, but the social security will make it easier for them to fill out forms and get past the computer systems that do not recognize less common types of, you know, bases for eligibility. Do we have any other?
We had another question about whether somebody that was born in Puerto Rico is an American citizen. So I did want to add that when we say born outside of the US, we do mean outside of the US or any territory. So if folks were born in Puerto Rico, Northern Mariana Islands, or the US Virgin Islands, or any other US territories, they would still have US citizenship and should be able to get a US passport without issue if that was needed to show citizenship. But any birth certificate and things like that from the US territory should be sufficient to show that they are in fact citizens.
And thank you for that question, because that is 100% true and did not pop into my head when we were, you know, you never think of everything. Can we go to the next slide? And I'm going to try to go a little quickly because I love that we're getting these questions. This is wonderful. So just this is a reminder we mentioned before, in the sense of get all children to immigration attorneys, that children must follow the rules related to their status, right? And because they're children, they're usually going to need help from their grown-up or their case manager, et cetera, to make sure they're able to follow those rules. So they're going to need to continue to regularly consult with an attorney. You know, that attorney can let you know, come back in a year, come back in 2 years, usually give some kind of estimate. And then also, if there's any involvement with delinquency or the criminal justice system, even just accusations that are dismissed, unfortunately, immigration can be incredibly strict, and it is not always intuitive what is the most strict, right? It's not like it's the most serious conduct. Sometimes it's conduct or behavior that is fairly common among youth, especially teenagers. So we just want to make sure that if anyone has any involvement with law enforcement as a potential, you know, perpetrator or delinquent, not as a victim, that's separate, but if they're accused of anything and it's, you know, there's any paperwork about that, we want them to consult with an immigration attorney right away. And also, no, and we want the immigration attorney to explain things to them, because we also don't want to scare children to think, oh my gosh, I messed up once, it's all over, might as well just quit school and, I don't know, panhandle the rest of my life. I'm out of options, right? And then maybe make some choices that are maybe even worse than the first choices. So we just want to be really careful that we explain things to kids with transparency. We don't want to make it sound way worse than it is. And how bad it is depends on the details. We also don't want to make it sound like, oh, you never have to worry about anything, because that's just not the reality they find themselves in, right? They have a lot of responsibility on their shoulders to maintain their immigration status, even though they're kids. And then also, sorry, you go.
Oh, I'm so sorry, Jackie. I did want to add one of the things that to keep in mind for this. Many times teens or kids that were born in the US might get a slap on the wrist for something, or go through the juvenile delinquency system, and it'll be a quick little thing, and it won't have very many consequences. Whereas for an immigrant child, or a child that does not have any status, or whose status is in progress, or is a green card holder, depending on the facts of underlying that accusation, if they get a conviction, that can affect their status very severely, even if it's something, at this point, we're about to, we have medical marijuana and things like that. And so, whereas once they turn 18, if they get that card, or 21, whatever it is, it would not be a big deal. For the immigrant child, even if they have the card, that would be a huge deal, because it is still federally prohibited. And so while it might just be totally dismissed and it's like, oh, no biggie for a US citizen child, that's not the same for the immigrant child or young adult once they age out of the system. So we want to make sure that kids know that before they even get to that, because if they do have access to FAFSA and all of those things and they go off to college, we all do stupid things while in college, but they don't always carry such severe consequences as they do in the immigration legal system.
Thank you for that. Yeah, so important. And then also, if the status is within 1 year of expiring, or if their work permit's within 1 year of expiring, we definitely want to check in with an attorney, unless you already have a plan, like right at the 9-month mark, it's already set, that's fine. But if you don't already have a plan, please check in. And generally kids can't leave the US until they have their green card. And even once they have the green card, there's rules about how long they can stay. So we recommend staying within the contiguous US. So in this case, I'm going to pull out Puerto Rico, just because if the plane lands somewhere, depending on the situation, it can cause issues. So would recommend contiguous. And I know a lot of foster families and group homes are going on cruises, which is so fun, but unfortunately these kids can't go usually, and it can be really sad for them. So just, we want to prep them, and we don't want them finding out. I had got a call from someone when they were on the boat. I was like, no, get off the boat. This wasn't a current client. This, I think a current client would have, but it was a call about someone. So anyway, yes, it's unfortunately, there's just a lot of rules that we got to follow, and we want to be careful because the consequences can be severe. Okay, next slide, unless you have any more for this one.
I just wanted to add, I totally agree with you with staying within the contiguous US. I have heard other attorneys give different advice. I am pretty risk averse. So my take on this is, even when folks have what's called advanced parole, which is something that allows you to leave the US if you have some sort of status pending, I think you should have a really, really good reason why you're leaving the US, and you're always at the mercy of the officer that's at customs that day or at immigration that day. It allows you to leave, but it doesn't necessarily allow you to come back in. So unless there is a very good reason why this person needs to leave the US, I usually advise folks not to leave. And if they are going to travel, we have 50 states. We have all sorts of ecosystems and things in places where they can go. And so to try to stay within the contiguous US until they have that green card in hand, and to make sure if the green card is close to expiry, when they're traveling, that they are back in before it's expired, and that they don't stay out longer than it's allowed, because then it can cause issues down the road with the U.S. I'm sorry, ICE could claim that the green card's been abandoned at that point if they stay out too long. So we want to make sure to avoid those issues. And so I'm with you. I usually recommend folks don't travel, but I know that's not feasible for everyone. And definitely before making any plans, they should consult with the immigration attorney right away to make sure that nothing jeopardizes that status or potential status.
Next slide, and yeah, I'll add for SIJ, there's no advanced parole, so definitely no travel, hard no travel for SIJ kids. And this is just really quick. Someone just asked a question actually about the timeline, and this does not include the processing times for things because that varies, and I did not want to send that out into the internet to stay forever. So it's longer than what this would imply, but we're going to, for T visa, we're going to apply, we're going to get a work permit upon a bona fide determination, which is pretty much when they have a chance to look at it and say you submitted the basic requirements. Then eventually we'll get a decision, which will hopefully be a T visa approval. Then 3 years after that approval, we must apply for the green card, and we must 100% apply. Well, we're able to apply at 3 years, and we must apply before it expires at 4 years. And the kid can't have any big trips for sure. And generally we recommend don't travel, but you can apply for advanced parole for T visa, since we mentioned that a little bit. And then 5 years after the approval, and if the child's 18 by then, they can apply for US citizenship. So frequently folks will say, oh, can you help get this kid citizenship? And it's like, if you're looking at like a 10-year horizon, yes. So just want to keep that in mind. And one of the things that's important is not to say you're a US citizen if you're not. That has serious consequences as well. So we want to be careful in documentation. Like if you're having the kid sign something, make sure you didn't check a box saying they're a US citizen. And then for SIJS, we're looking at applying and then hopefully receiving approval. That's usually a faster process for the processing of it. And then almost everyone, and hopefully all of our kids will receive deferred action for 4 years, and they can apply for a work permit. And that's usually takes a little while, not too long though. The work permit will last for the 4 years that their deferred action was granted. And then they can request to renew it, because unfortunately there's a really long backlog and we cannot predict exactly how long the backlog is for any one person. But not me, others who have done the math and looked at the data estimate that it's more than 10 years for kids who filed recently. And that's because they're waiting for an employment-based category 4, which you don't need to know this, look it up, visa category, as stated in the Department of State's visa bulletin. So there are lots of lovely explainers about this. We're not going to get into it today. But bottom line is, maybe once a year, kids can check, or their caregivers can check something called a visa bulletin and see whether or not they've reached the date that they submitted their SIJ, their priority date. And that will be, and that's another reason why things are always urgent. We want to get stuff filed. And then it's going to maybe be 10 years if it's a recently filed one. And then 5 years after they get their green card, once they're allowed to apply for the green card, it's approved. 5 years after they've had their green card, that's when they can become a citizen. And probably they're all going to be 18 by then, so we don't have to worry about that part. And I think we can move on. And I'll hand it back to Nicole unless we have any other questions about these topics.
I don't see any questions. I apologize. You might hear my dog in the background because it is storming here and she's freaking out. So I did want to highlight also with SIJ as one of the considerations that the child might have when applying for SIJS is they, unlike the T visa, they won't be able to petition for the parent. And so while we might think that that is the best option, it might in fact be the best option, especially with older kids. I think they might have that consideration of not cutting out eligibility for the parent. Of course, the client is the child, but in the interest of being transparent, I think it's important to let them know that that is part of the relief, that they might not be able to help their parent get status later on. Um, but so I just wanted to add that as well. When we talk about exploitation and trafficking victimization, like Jackie mentioned earlier, for the purposes of this presentation and qualification for services or OTIP letters, we're basing everything on the federal definition. The graphic on this slide does not belong to me. It is from the Coalition Against Slavery and Trafficking, and they're one of the resources on our resources page at the end, so you can get this information or get their entire advisory that surrounds this graphic that I'll go into more in a second from their website. So one of the things that they found at CAST and I've found through doing this work is that the way that the statute is written tends to confuse folks about what qualifies as trafficking and what doesn't. So what they did was essentially flip the definition on its head and started with the purpose of what the person was made to do. Because many times we hear things like, oh, they didn't pay the person, or anything that is outside of the realm of trafficking victimization. So the purpose of the federal statute, or the reason they were able to pass that statute, was under the Commerce Clause, which is what's helped me to kind of figure this out. And so there has to be some sort of exchange, some sort of economic aspect is what we're looking at. So for the purpose under the federal statute, we're looking at either involuntary servitude or forced labor, debt bondage, which is when there's a debt that never goes down and it's presumably being paid off by the labor or the work that the person is being made to perform, or sex trafficking, which means that there was some sort of commercial sex, meaning there was an exchange of something of value. When we're talking about children, there does not need to be any force, fraud, or coercion for sex trafficking. Children cannot consent to sex. So any commercial sex that's being performed by somebody that's under 18 is essentially by definition trafficking. There does still need to be that exchange of something of value. So it still does need to be commercial sex, but they do not need to be forced, defrauded, or coerced into that trafficking victimization. Although there, of course, very much might be any of those things. They just don't need to be proven for trafficking, sex trafficking of children. The law does not consider that children cannot consent to labor. So children can consent to labor. And so any involuntary servitude or forced labor does have to be, they have to be induced to do that by either force or coercion. Fraud is still a part of it. However, the definition of involuntary servitude and forced labor includes coercion as part of it. So you have to have coercion at a minimum to show involuntary servitude or forced labor. And then the process is what actions the trafficker took to get them into this condition of forced labor or sex trafficking. So whether they were recruited, harbored, which means they were giving them a place to stay, or they were keeping them in a home or in a place, warehouse, wherever it is, transportation, provision and obtaining, or just kind of a catch-all, like you brought the person and were essentially, quote unquote, lending them out or selling them for whether it's labor or sex trafficking, and you were providing them to other people, or you obtain them for those purposes. And so this is what's needed for the T visa and what HHS would be looking at as their definition. Based on the federal definition, I always, when we're screening folks for T visa or for trafficking victimization or T visa eligibility, I always say there's kind of a two-layered screening, because what might be trafficking in, I think Jackie said it best. Like, none of us can say whether somebody was trafficked or not trafficked. We can give an opinion on whether the fact pattern meets the definition under the federal definition or the Florida definition. But we can't say without, we can't promise that this is or isn't, and that it will or will not be granted by USCIS. So while for eligibility for services in my organization will tend to be more inclusive, even if it's something that if I was filing a T visa for that person would be a very hard argument to make. So there's different determinations depending on what the legal needs are. But generally, this has been the easiest laying out of the federal definition that I have found that helps me to just kind of categorize what the person's telling me they were made to do, how they got in, what the trafficker did to get them into that position or to keep them within that scheme, what promises were made, if there were threats, of calling immigration. That's usually a huge one, and it's basically always coercion. Threats of calling the police, threats of taking them away from their parents or getting their parents in trouble, things like that. And then what processes or what actions were present. So whether they had them living someplace, they had no control over where they were taken to perform the work and things like that. And then let's see. So these are some additional definitions and examples of what might constitute coercion. And so under the definition, threats of serious harm, and it can be physical harm or it can be harm to their reputation, getting blacklisted from certain types of employment, or threatening to go to, friend groups or school or things like that that threaten their reputation. Anything that leads them to believe that family members are going to be harmed or things that they care about, and threatened abuse of the legal process, including things like, I'm going to get your parents in trouble, I'm going to get you in trouble, I'm going to call the police if you don't do what I'm telling you to do, making things up, or taking them through any legal process, whether it be a lawsuit or dependency or anything like that, when they shouldn't be in that process. And then, as I mentioned before, with the Commercial Sex Act, we're talking about any sex act that is done in exchange for something of value. It doesn't need to be money. It can be additional access to, and these are kind of examples, and everything's going to be in the context of the full fact pattern and what the person experienced. But it could be that if they didn't comply with what they were being told to do, food would be withheld, or they would have additional access to phone calls to their family if they performed what they were being asked to do. But it doesn't necessarily have to be monetary, but there does have to be the exchange of something of value. Jackie, do you have anything to add on the definition?
No, I know we're having great, I'm responding to a chat. Definitely, you can always dig more into wonderful training. So I'm gonna try to keep it and keep us moving.
I do see one question on here about, does being brought to the country to work by your parents count? Would that qualify as coercion? So I hate to give the standard lawyer answer. It's going to depend, and we definitely would need more information to determine whether that's the case. But I'll take it back to the EMP model. What we're looking, I don't think that in and of itself being brought to work is going to necessarily be trafficking. That really depends on what they're threatening to do. So going back to that definition of coercion, are there threats of serious harm or physical restraint against anyone? What are they being told will happen if they do not comply with what they're being told to do? Again, minors are considered to be able to consent to labor, even if we we find that distasteful. I tend to agree, and I know that the Florida statute is a little bit more expansive than the federal statute in terms of that, but I also want to highlight that the trafficking isn't the being brought into the country. Trafficking can occur domestically. So it's not when we talk about folks entering the border or entering without inspection, we can talk about that's an unlawful act against the border or against, this imaginary line that folks are coming in and out through. However, trafficking is a crime against a person. So we're talking about what they were being made to do, and what was the purpose of the trafficker having them in that scheme, and how they did that. Were there promises made? Were there threats of harm made? Was there actual physical harm? And so those are all considerations that we need to make. Just because a child is working is not necessarily trafficking, but it does open the door to ask additional questions and see whether the environment is exploited or whether there is trafficking there. But I do want us to remember that it's not only folks that are coming in through the border, but trafficking. And most of the clients that I've worked with, I think, with the exception of a few, have been trafficked domestically, and their trafficking had nothing to do with their entry or how they came into the US. So these are some examples of trafficking victimization that we've seen in common industries that they occur in. We see, and for children and really for adults, but we're focusing on kids. A lot of times we can see domestic trafficking for domestic labor. And I think usually those cases might be a little bit harder to spot and a little bit harder to get relief for, because I know USCIS kind of takes a position that you have to do some chores, but really going through the analysis, and that's the importance of having an immigration attorney that's knowledgeable about these issues to figure out, was it a kid who just didn't want to do chores, which is not really no one wants to do chores, but what were they being asked to do? Is this really more of like an employment relationship where they're being asked to do things from 7 a.m. to like 9 p.m. and were they in charge of everything? Did they have to cook? And how were they being treated when they were not complying with the orders of what they were being asked to do? We also see it, in construction, in farm work. It might be common in other areas of the world to have children working the fields and stuff like that. So children will often not identify the fact that they're working. And even if the conditions are not great and they are being coerced into labor, as victimization. So that's why it's important to ask those questions and determine whether there is, and there might not be, and being transparent. This is why I'm asking you these questions. There might be some opportunities for relief, and I just want to make sure that you're connected with all the services that you might need. And so being transparent about why we're asking questions and keeping our questions non-judgmental, not asking why would someone do that. Why, the why question always comes across judgmentally. And so again, it might be common in other cultures to have children working from a young age. So we don't want to alienate the child from the start of the relationship or at any point during the relationship by assuming that the parent's doing something wrong because they had them working on the fields or something like that. Keeping in mind that cultural context and whether it fits the definition under the US definition or the federal definition, but always building that trust with the child and making sure that we're being transparent, whether the child's parent is likely to get in trouble for things. That's always going to be something that the child has, top of mind with a lot of the children that I've worked with. So I think it's important to keep that. And one other thing that we really wanted to highlight was the forced criminality aspect, because that labor that they're being made to perform could be a criminal act. It could be, drug sales or delivery or returning things or shoplifting, things like that. And so we want to make sure that we're not stereotyping folks and that we're providing the courts and service providers enough information so that they are knowledgeable about forced criminality and any potential risks of engaging with legal processes, ensuring that, you know, if the child does have a record, that we're accessing any expungement or vacatur that might be available to them if they are a victim of human trafficking, to address those things so that they don't affect their immigration status down the road. Anything on that, Jackie?
No, I think that's all great. I think we're running out of time, so I was going to suggest that we maybe skip the case examples, but let everyone know that we have included case examples. The first slide shows just the fact pattern. The second slide points out the coercion or fraud, the types of acts that were related to the for the purpose part that Nicole was talking about. And we boiled it down to for the purpose of labor or for the purpose of a commercial sex act for, you know, simplification purposes. So I think those would be great to review on your own. And if you have any questions, you can always reach out to us. Like Nicole said, it's can be very fact dependent. And I just want to clarify too, because, you know, this is not an identification training by any means, especially for kids, like a coercive environment can make them fear serious harm. So it doesn't, I don't want to give the impression that there needs to be like this direct threat, this, then that. It is broader than that, but then when we get broader than that, we really need like the full context and usually to have interviews to be able to, you know, we can ask some questions, give some ideas, but usually to do a full determination, we really need to interview the client, or again, we want to get them to someone who can interview them. And do you want to talk about the resources?
Sure. So once you get the PDF, you should be able to click on the links. So everything that's underlined is a link. And so we wanted to give you that information. The first link is on the Office of Trafficking in Persons, or OTIP, and that's where you'll find that training on how to request the letters and the forms where you can request the letters. The ABA Children's Immigration Law Academy has great webinars and resources for working with immigrant children or children born outside of the United States and providing immigration assistance. That is not necessarily, you know, for you to become an immigration expert, but really just to have a background on what the issues might be beyond what this training is able to address. And then the Coalition to Abolish Slavery and Trafficking, they are the nationwide training and technical assistance provider that's funded by the Office of Victims of Crime to provide that service. It is free. They have on-demand trainings. They have lots of documents. They do technical assistance. So if you want to take any T visa cases or anything like that from, you know, either of us pro bono, we're able to provide some guidance, but CAST really is, that's who I rely on and who I send all of my staff to train through, because they have so many amazing trainings and they're all free. And then lastly, we'll put up, if you have any questions or want to workshop cases and things like that, here is both of our contact information. And if you can please take the survey, the QR code is right there. And I think the link was posted earlier also. We would really, really greatly appreciate that. So Jackie, anything additional?
No, just happy. I know we're a little over time. Happy to stay on and answer if there are questions, or yeah, feel free to reach out in the future.
Absolutely.
I'm about to post on the chat all the information for the CLE. It will also go out as an email. I'm gonna read it out loud, the CLE code, in case anybody wants to write it down. It's 24077326N as in Nancy. It will, all of this information will also go out as an email within 24 hours. I know a lot of people asked questions on the chat. They were being answered live as we were going through them. This was a great presentation. I know we're a little bit over time, but before we officially wrap up and allow time for additional questions, I want to thank our speakers and everybody that attended. We had a lot of attendees today, so I want to thank our speakers again. And back to you, Nicole. I'm going to open it up in case anybody has questions that they want to post on the chat or the Q&A or anything else that you guys want to add.
Thank you so much, Jorge. Thank you, everybody, for coming to the presentation today. I'm available to stay on for questions for a little bit, so we'll give it a few minutes to give folks time to type in the chat or the Q&A. But thank you so much, everybody.
Jackie, I don't know if you're trying to say something, but you're muted. Just want to let you know.
I was going to say, just to fill the air while we give it a couple minutes, just in case there's a question. I did respond about the Puerto Rico question because I thought, oh, I should mention that while Puerto Ricans are U.S. citizens, and that is wonderful, it can be more challenging to get their birth certificates. I've heard. I have not had a Puerto Rican client, again, because they're U.S. citizens, and they don't have like an immigration process like some of the other U.S. citizen clients that I have. They don't need that. But it can be hard. So definitely I encourage everyone, U.S. citizen child, Puerto Rican or contiguous state born U.S. citizen child, Puerto Rican born U.S. citizen child, any children in general, especially with the Real ID Act now, it is very challenging. And we're hopeful that all kids, but well before they age out, have a Florida ID or a Florida driver's license. But I know that's not the case from situations that I have personally seen. And so that is a great way to test if they have the kind of documents they need, because if they can't get one, they probably don't have the documents they need, and it can be a lengthy process for U.S. citizen kids who were born anywhere in the United States to get those kind of documents if they don't already have them. So just want to flag that for just document stuff can be challenging. Make sure kids have birth certificates before they age out. Make sure they have a Florida ID or driver's license before they age out, or before they have a permanency as well, right? Reunification or some other kind of permanency. Please make sure that happens, because caregivers might not know how to do it. And it's our obligation too, because these kids are our responsibility.
Mm-hmm. And Jorge did post on the chat the link regarding information on birth certificates in Puerto Rico. I'll also kind of say if the child is in deportation proceedings, ICE trial attorneys technically have the burden of proving that the child is not a U.S. citizen. So if the child lets you know that they were born in a U.S. territory and for whatever reason they're not only in care but in deportation proceedings, it's happened in the past. Bring that up to the ICE attorney right away, or have the immigration attorney on the case make sure that they know that, because ICE is not allowed to put U.S. citizens in deportation proceedings, and they have the burden of proving that the person is not from the U.S. So they definitely don't want to be in that position, I would imagine. So make sure that everybody who needs to know knows that information. And thank you, Jorge, for posting that link.
I have zero experience with immigration, but I'm from Puerto Rico, and I've had a few folks reach out to me specifically because of El Registro Demográfico. On that site, you can actually toggle the languages, so it will switch from Spanish to English. If any of you ever have issues with trying to get any documents, I can't make any promises, but reach out to me. I'll try to reach out some contacts that I have in Puerto Rico and see if I can help in any way. But yeah, it's a struggle.
We love that. We love that. Thank you.
Thank you.
All right. I don't see any questions in the chat. I do still see we have like 65 people on, so please feel free to ask questions if you need. But other than that, I think we can probably wrap it up.
Yeah, all I see is a bunch of people that appreciate this great, amazing presentation. So thank you again to our speakers, Nicole and Jacquelyn. This will all be emailed. It will be posted soon on YouTube. So if you know of anybody that was not able to register or attend, let them know that it will be on YouTube, and I'm happy to share all the materials. So thank you again to all of our speakers, and have a great Tuesday. A great rest of your day.
Thank you, everybody.